Hey everybody, it's your old buddy Ernest, beaming to you live from South St. Louis. I talk to you about your heat pump. Heat pump, schmeat pump. I know, we're here in fashionable and sunny South St. Louis to talk about the tax sale. And so we're going to start here in about 1 minute. How's everybody doing? Just to let you know, you can send in questions on the chat, or you can call in at 636 tax sale, and Lena might be able to pick up the phone. The phones are ringing off the hook. The operators are standing by. And moving now to our slides, we're talking tonight about Missouri tax sales, and specifically about the 2024 updates. So we're not starting at the beginning. We're just starting with what we already know, and then we're moving on with what's changed since the last time that you and I were together. Since the last time that you and I were together here on the YouTubes and the interwebs. Moving now to the tax sale update. I'm an attorney. I'm not your attorney, or maybe I am. I don't know. This is not intended tonight to be legal advice related to anybody's specific situation. Instead, rather, the choice of a lawyer is an important decision and should not be based solely upon advertisements. We're going to try to be quick tonight. I'd like to get this done in 45 minutes. We'll see. You can put your questions in the chat. You can call 636 tax sale and see if Lena can answer the phone. She is swamped with questions right now. And we're not talking about anybody's specific questions related to their specific legal matter, because that's the sort of thing you should call me up about tomorrow. We know what a tax sale is, and therefore we're going to watch the old videos. We are not starting at the beginning tonight. And mostly what we're talking about tonight is the post-third lists are out in most Missouri counties, specifically including the county of St. Louis, which is otherwise known as St. Louis County. And so we're going to talk about that a lot. The St. Louis County's collector's office has problems. They've lost a lot of institutional knowledge, and a few people aren't there anymore. They're down to 1.5 persons, 2.5 persons, we don't know. They're yelling at people on the phone. They are doing 60 and 90-day delays for everything that they do. The deeds for many of the August tax sales from 2023 are not yet available, and it is very bad. We're also going to talk about statutory changes in the law that affect every Missouri county other than the city of St. Louis and Jackson County, including sewer bills, post-thirds, land banking, chickens and HOAs, the new sheriff in the city of St. Louis, service by publication, what the hell, federal stuff, and sealed bids. So it's going to be a wild ride, buckle in. My slides are going to include tonight characters. Those are people, fictional people. Ron Jackson, Tammy, who are involved in quiet titles and tax sale litigation, because a quiet title suit is almost always necessary after the issuance of a collector's deed in a Missouri county other than Jackson or the city of St. Louis. And that quiet title suit, no matter what your attorney does, may not satisfy Tammy. Here's the state of Missouri. So moving to the western part of the state, Jackson County includes Kansas City and some other areas, and we're not talking about that at all tonight. We are, however, talking just a little bit about the city of St. Louis, which has a similar tax sale situation to Jackson County, and mostly about St. Louis County, but also about the entire rest of the state of Missouri. In the general timeline for a tax sale, and guess what? St. Louis County waits 3 years, which is the maximum, not the minimum, the maximum number of years that the county can wait to start tax sale foreclosure, but other counties do not. So Jefferson, St. Charles, Warren are probably going to wait 2 years. Crawford is going to wait 1. St. Louis County is going to wait 3. That is the maximum. So you see here that the taxes on the real estate go unpaid for 1920 and 2021. And then in August of 2022, St. Louis County is going to offer the property for sale for the first time. August of 2023 for the second time. August of 2024 for the third time. Now, what are they offering on 1, 2, and 3? They are offering the tax lien, not the property. By the time you get to December of 2024, however, in the example that I have up on the screen, we're now offering the property for sale, not the lien thereon. So therefore, you're buying a tax lien in a first, second, or third, and maybe the real estate later. The bidder may...
Question 1, this is the example we're asking about. Here's question 2.
All right. We have a question coming in on the phone. The bidder is probably not responsible during the pendency of the certificate or the redemption period until they have record title, but the city of University City or another municipality in St. Louis County will still tear your house down. On a first or second offering lien, and so going back here, that's if you bought this magical, hypothetical example property in August of 2022 or 2023, there would be a 12 to 18 month right of redemption. If you bought this property, however, in August of 2024, earlier this year, there would be a 90 to 135 day right to redeem. And the important point about that is we're going to have a change in the law this year, and we do. So on a post-third offering, that means the county tried to sell it 3 times. Callaway County, St. Louis County, Taney County, Phelps County, doesn't matter. They tried to sell it 3 years in a row, and nobody bought it. Now it goes on the post-third list. And on a post-third offering, you're now dealing with a property that you can buy over the counter, not in an auction. You're actually buying the property, not a lien thereon. But there are significant constitutional problems with lien holders, especially, despite the fact that there's an incredible amount of tax delinquency here, sometimes 6, 7 years. And it's very awful because even though you are now bidding down or offering an amount for the property rather than bidding up at an auction, there are constitutional problems, and we're going to get to them. Beginning this year, and the reason why we're here tonight together is that you can get an offer in on a post-third and proceed as if it's a third, which means that you will have to get a title report and you will have to send out certain notices. You will have to wait an amount of time. You may have to do other constitutional things, and that is a good thing most of the time. Moving on. Redemption is a magic word. It's a vocabulary word. It's a religious word. It's a criminal justice word. But here it means that redemption means pay the taxes and keep your property rights in the property. Whether you're a mortgagee or a judgment creditor or the owner of the property or her granddaughter or her nephew. Theoretically, there is no right to redeem on a post-third due to the extreme tax delinquency. However, the 5th and the 14th Amendments get in the way, folks. They say that no person, any person, can be deprived of their constitutional rights to property without due process of law. And and so that's a lot, and it's included in the Fifth and 14th Amendments to the United States Constitution. That also includes double jeopardy, eminent domain, and a lot of other things. But here, for the tax sale context, we mean that no person shall be deprived of her property rights without due process of law. In the context of a tax sale, due process generally means, according to the United States Supreme Court, a really, 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 really good attempt at notice and a right to redeem the property. In 2024, House Bill 2062 was enacted by the Missouri legislature and signed into law by the governor. That began in Missouri law in late August of 2024, and it affects many areas of Missouri tax sale law. Specifically, and this is the most important thing that we want to talk about tonight, is section 140.250.5. Now I'm going to get into horribly nerdy territory. You can purchase a post third in a Missouri county as if it was a third. Well, why would you want to do that? We're going to get into that. And if you have to zoom in on your little phone there, we're talking about 14250.5. It says that a purchaser at a post third sale may proceed as if it was a third sale, sending out notices, ordering a title report, and demanding a deed after 90 days goes by. And that's very important in certain circumstances for certain people, and it's up to you and your lawyer. You can elect to treat a post third as if it's a third. So when you put in your offer, that is, let's say that the sticker price on 1234 Schweitzer Boulevard in Jennings is $10,000. And that includes the sewer lateral, penalties, interest, etc., etc. And you want to offer $9,900 for 1234 Schweitzer Boulevard in Jennings, then you would do so using all the normal forms on St. Louis County's website, or Callaway County's forms, or a cover letter, or a regular letter, and a certified check, a cashier's check, a whatever. And you would say in that letter that you want a certificate of purchase, you do not want a deed. You're only buying the lien, and then you want 45 days to get your notices out, order a title report, affix stamps, go to the post office, send by certified mail, send by regular mail. Then you want to wait 90 days to redeem. Well, why would you want to do that? We're going to get to that in a minute. And then you would demand a collector's deed. Here's the problem. There are 115 counties in Missouri, or rather 114 counties, including the city of St. Louis, which is not a county, but is rather an independent city. And none of these collectors of revenue, especially in St. Louis County, are going to know how to handle the first time that they get one of these things across their desk. Why would you want to do this? Well, it's the difference between a tomato plant and a renovation. So, somebody called me a few years ago and they said, Dale, you know what? I just bought this vacant lot next door to my house, and I'm going to put out a swing set for my granddaughter. And I'm going to put out a tomato plant. And I wish that you would have started on this quiet title lawsuit to clear up the title of the property, and I wish you would have started on it yesterday. Didn't you get my message on Saturday afternoon? And I said, for the love of God, why? Why would I say that? Well, because who's coming for this vacant lot? Are we looking for title insurance on this vacant lot? Are we borrowing against it? Are we selling it to someone who needs a loan to pay our purchase price? The answer to all those questions in the hypothetical is no. Now, nevertheless, if we're building a new house, if we're borrowing against a house for construction, If we're putting up a skyscraper, as in the slide, well, then we would absolutely want good title. And in order to get there, we would have to order a title report. And we might do that before we make an offer on a post-third tax sale. Here's our first quiet title character. Get out your bingo cards and put on the sticker. It's a dumb lender. A dumb lender might be out of business. It might be named something. It might be an IRA. It might be seller financing. And anyway, I don't know about you, but when most people have a mortgage on their house or their business or their land or their farm, they have to pay the taxes and the insurance out of escrow. So every $500, every $1,500, every $5,000 that goes in, you will have to pay a certain portion of that toward the taxes and the insurance. And if they aren't, or if the lender doesn't require that, then they aren't paying attention. And Missouri law has always required a lender or lien holder to pay attention to newspaper advertisements. Whether that comports with the 5th and 14th is up to the courts. Turning now to the next most important thing. So let's go back here. You can treat a post-third as if it's a third. That requires sending a notice to the collector and waiting around for a hot minute and maybe losing your property interest and maybe getting your money back. That is just all there is to it. We have to parse this language here in this statute, and you might want to do that, you might not want to do that, but in many cases, if you're doing anything involving money with the property that you're buying, you're going to want to do that. Dumb lender, we talked about that. Moving on to the next option in the next thing that we're talking about tonight in our 2024 update, land banking. So for most Missouri counties and for many municipalities in St. Louis County, the law now allows the county or the municipality to opt into Chapter 141. Why? Everything we've been talking about so far is Chapter 140. That's the Jones-Munger Act. It's an administrative system. It allows for administrative tax sale foreclosure followed by a quiet title conducted in front of somebody wearing a black robe. In 141, which is the tax sale system that applies to Jackson County, which is Kansas City and areas near there, it is a judicial foreclosure system, such as the city of St. Louis, which means that the government does the due process notices. Nobody can come back. Better title. A sheriff's sale. Conducted out in the open. Not a sealed bid auction. Not a drop it off. And no right to redeem after the auction. The right to redeem occurs before the auction. A land bank in Springfield, Missouri, St. Louis County, Missouri, would look like the city of St. Louis LRA, but it would be a little different based on different legislation. And municipal transfers in St. Louis County, which is what happens now. So guess what? Hillsdale, Jennings, whoever, whenever the list gets all the way to 7, 8, 10 years delinquent, they pass an ordinance and they say, hey, county, we want these properties. And then they sell them. And they sell them to the highest bidder. And they sell them with strings attached. However, the problem is that they come along with god-awful problems based on the 5th and 14th Amendments because no notice has ever gone out to a taxpayer or to her lender or to her judgment creditor. And that's the major problem with these things. So, moving along to why a land bank might be desirable in Springfield, in Callaway County, in Taney County, in Camden County, or in St. Louis County, we have only to turn to Castle Point. So Castle Point is an unincorporated census-designated place in St. Louis County. It is northwest of 367 and Chambers. In Castle Point, there are tons of properties. They're not worth much these days, which is very bad. And there are 144 properties in Castle Point on the 2024 St. Louis County post-third tax sale list. Can you see here why a land bank would be helpful? And by that, I mean a land bank would wipe out the taxes, the mowing fees, the demolition fees. It could put 2 or 3 properties together and sell them as a single unit. It could sell them based on the street frontage. It could sell them based on the square footage of the vacant lot. It could sell them based on the square footage of the vacant house. But what wouldn't happen is that there are 144 properties that nobody is taking care of in an unincorporated area of St. Louis County, and that wouldn't affect any mayor or any city council in any municipality in St. Louis County. Turning now to sewer bills. People call me 17 times a day, 27 times a day. They want to know, what about this sewer bill, Dale? Well, historically, the Metropolitan St. Louis Sewer District wiped out a sewer bill upon presentation with a sheriff's deed in the city or a collector's deed in the county. Then, in 2021, 3 years ago now, a case came down. It was a Jefferson County case from the Court of Appeals, and it says, hey, sewer bills survive a tax sale, they always have. MSD took the exact opposite approach. We're going to get real aggressive. In 2022, however, the Missouri legislature changed the tax sale law for the city of St. Louis and said, hey, sewer bills don't survive the tax sale. A property bidder at the tax sale sued for quiet title. The tax sale amount and the amount of surplus from the tax sale greatly was smaller than the amount of the sewer bill. Therefore, the sewer district said, no. And so the case is up on appeal. There are further refinements in 2024, and what I mean by that is that some of the underlying statutes have been changed by the Missouri legislature in 2024, and it'll be very interesting to see where this goes. Moving now to the chicken litigation. We have a thing in Missouri called the single subject rule, and that means that a certain House bill or Senate bill that goes out can't affect daycares at the same time as it affects tomato plants. And what I mean by that is that the bill is supposed to be concise and put together, and House Bill 2062, which is the tax sale law changes that we're talking about here, is alleged to not be. Now, all of the things in 2062 involve real estate. And a lot of them involve the tax sale. And they involve land banking. They involve the sewer bill. They involve being able to purchase a post-third property as if it's a third. Nevertheless, there is a challenge brought by an Ozarks HOA, Homeowners Association, saying that this tax sale law 2062 violates the single subject rule because it also says that an HOA or a homeowners association cannot regulate the unit owners' keeping of chickens in their property. That litigation is pending, and the law is the law the way it is written until it is declared unconstitutional. Turning now to federal problems in our 2024 tax sale update, we're dealing with Missouri law. Whether we're dealing with Jackson County, Taney County, St. Louis County, or St. Louis City, we're dealing with Missouri law. And there's this thing in the Constitution called the Supremacy Clause, which says that federal law outweighs state law, certainly outweighs Kirkwood law, et cetera, et cetera. And there was a case a couple of years ago called Show Me Premium Homes, wherein the tax sale purchaser was trying to obviate or void or extinguish a lien from the United States government. And that was declared to be wrong. It continues. The procedures from the United States Attorney's Office used to always be that a judicial foreclosure, such as conducted by Jackson County or the city of St. Louis, or that could be conducted under state law, would be sufficient. But they've taken a different approach. You really have to watch out for these people, but the reality is that there's a new administration coming in Washington, D.C., and after they get through the first 90, 100, 300, 750 days, maybe we can take a look at this again. And this refers to liens from the DOJ, the IRS, HUD, the FDA, the FHA, so on. Turning now from Missouri counties to the city of St. Louis, we have a new sheriff in town. The sheriff for the last 8 years has been Vernon Betts, and maybe longer. And Alfred Montgomery got more votes in the November election, or rather in the August election. And so he's going to be taking the reins at the sheriff's office in the city. Why does this matter? The city of St. Louis sheriff conducts the auctions for properties that are delinquent and sued, and there is a judgment thereon in the city. The sheriff handles the schedule, which is usually May, June, July, August, skip September, then October. We don't know what the schedule is going to be for this coming year, and the sheriff is simply going to have to do what he needs to do and find some different people where he wants to, and clean house if he needs to, and then set his schedule and so on. The last thing that I want to talk about is service by publication. And that requires talking about a certain character in a quiet title action. You buy a property, St. Louis County, Franklin County, Hickory County, and the property was owned at the time of the tax sale by Ron Jackson. Well, is Ron Jackson the first, the second, the third, junior, the fourth? Is he incarcerated? Does he have sewer bills? Does he have federal taxes? Did he pay his car note? Is he incapacitated? Is he incarcerated? Blah, blah, blah. Big problem. A lot of times when we do a quiet title action to shore up a collector's deed, and this is one of the reasons why we need judicial foreclosure on some, one, or all of our properties in Missouri, we have to end up filing a quiet title. And then, if Ron Jackson is unknown to us, we went on Austin Lane. We went on Cuta's Funeral Home, Hoffmeister, Ronald L. Jones, The American, the Post-Dispatch. We couldn't find our Ron Jackson. That's a big problem. Grantees you see in deeds don't even have to sign in most Missouri counties other than the city of St. Louis. There is no requirement for a date of birth. The proper names such as Ronald or Ronnie or Junior or Senior. There's no requirement for a social security number. The person named as a grantee in a deed in 114 Missouri counties doesn't even have to exist. You can deed your property to Donald Duck. Therefore, there is frequently no other choice but for to handle service in the quiet title by publication of notice in a legal newspaper that very few people read. It's allowed by the courts, but underwriters, and by underwriters I don't mean fire, I mean title insurance underwriters, they hate it. They want you to wait much longer and they want to embarrass your attorney. Even knowledgeable title companies now want to wait another year. What do I mean by that? Investors title company is the most likely to insure on tax sale property in the St. Louis region, and even it now wants to wait another year after the judgment is entered in a quiet title. So that would be purchase of a certificate, send out notices, get a deed, file a quiet title, serve by publication of notice if you can't get service anywhere else, and then wait another year, a whole year, in order to be able to sell your property or borrow against it. And that's because Ron Jackson, we already learned about him. He might be deceased, he might be disabled, he might not even exist, he might be the third, he might be the second. How many Ron Jacksons do you think there are in Callaway County? And there are even more in St. Louis County, period. And the other reason why we're particularly concerned about this is another one of our quiet title characters, ding, 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 and that's Tammy. Tammy is fictional. She works at the title company selected by your lender or your buyer or your buyer's lender. Therefore, she is very, very important because she is standing between you and your check for your investment and for your sweat. And she may pop up 6 months or 6 years or wherever from now. She works at a title company chosen by your buyer, chosen by your lender. She has on-the-job training, high school education, and high turnover. This person totally matters, and we're planning for her objections, but we have no idea who she is today. Turning now to one of the last things that we're going to talk about is sealed bids in St. Louis County. There are 114 counties in Missouri. 113 conduct an in-person auction. The city of St. Louis conducts an in-person auction. The only jurisdiction in the state of Missouri that does not have an in-person auction is the most populous county in the state, St. Louis County. It's the only county in Missouri that has you send in a sealed bid in an envelope and drop it off in a drop box. Mail it in so it can be lost by the post office. It is dreadful. This is a substantive due process issue as to both the taxpayer, as to the taxpayer's lien holder, as to the taxpayer's daughter, as to the taxpayer's grandson. It is extremely clumsy with investor resources. For instance, if you have $100,000 to spend at the tax sale and you have to write $10,000 checks, then you can't do any more. If, however, you went to an auction and you missed your bid because somebody bid more, or you went to the bathroom on the first 9 of the 10 and you would be there on the 10th of those sales, you would have $100,000 worth of resources to bid. And that would benefit the schools. It would benefit the public library. It would benefit the community college. It would benefit the zoo. And the way that St. Louis County is doing it right now is god awful, and it must stop, and they may not do it anymore. Therefore, you should call your council member, Dr. Sam Page, the Director of Revenue, Tony Smee, or the Collector of Revenue, Mark DeVore. This all started with the pandemic. Okay, we get it. Nobody knew what was going on, et cetera, et cetera. We can't let all these people in the same room at the same time. At the same time, the city of St. Louis moved their auction outdoors in case of good weather. St. Louis County moved their auction nowhere for no one, and it is dreadful. I'm also, if you're already one of my clients or we're in touch with one another, I'm going to be meeting with some people from St. Louis County. You can send me a message. If you're watching this a year from now, then forget about it. Call your council member. All righty. Moving on along, St. Louis County it uses the Jones-Munger Act. So do most Missouri counties, other than the city of St. Louis and Jackson County. Scott Walterbach, who's our colleague on the western part of the state, who handles many tax sales in the St. Louis area, has written a lovely little book that's available for $16-something on Amazon, or you can call his office. And Lena's watching our feed this evening, and is going to drop the link on Amazon in the chat. It's nerdy, it's stupid, it's beautiful, it's very smart. You should buy it. Everybody watching this should buy it. Everybody watching this in 2 weeks should buy it. And then we'll just see what's happening, because Scott's done a very good job with this book. I read it. It was a real page turner. I couldn't go to sleep. I had to finish it. I'm an attorney. I'm not your attorney. This is not legal advice related to your specific situation, and your choice of a lawyer should not be based solely upon advertisements, because it's important. Turning now to our questions. We have a question: why are some properties 6 to 10 years delinquent and not on the post-third list? You can call the county and ask, and they'll probably start screaming at you. The reality is, I have no idea. But anyway, they're going to probably tell you that they can't tell you. And the reason they're going to tell you that they can't tell you is that there's probably a bankruptcy filing, and you can ask them to take a look at that, or you can ask them for their manager, and you can ask for their manager. You can ask for the collector of revenue. You can ask for the director of revenue. You can embarrass them in the media, because these properties should be able to be purchased post-third if there is no reason why they cannot be, such as a bankruptcy filing or some sort of overarching federal rights. Will we be making any changes in the something in 2025? Will he? So this question is about the St. Louis City Sheriff, Albert Montgomery, who's coming in, or Alfred Montgomery. I have absolutely no idea. I met him at a barbecue on Broadway at a firehouse a couple of years ago when he was contemplating running for sheriff, and the reality is that he didn't know at that time that the St. Louis City Sheriff Office sold real property. And so that's unfortunate, but true. And I'm sure that he's gotten greatly up to speed since then. Will he be making changes? I don't know. Talk to him. Especially if Ms. Make It Happen is a St. Louis City resident, then she should be calling the sheriff-elect or reaching out to the sheriff when you see. Ms. Make It Happen just said LOL in the chat here. And so I'm an attorney. I'm not your attorney. It's been delightful, absolutely delightful being with you tonight. I hope you'll take a look at Scott's book. I hope Ms. Make It Happen will reach out to the new sheriff, Alfred Montgomery, who doesn't take office until January 1 or January 2. And I hope to see you at an auction. And when I see you at an auction in St. Louis County, I sure hope that it is in person. Good to see you, Jeremy Moore. Glad to be with you all. Good night.